evening, everybody. How exciting to be with you. And Connor, thank you for that great run-through of material that's so important that we know about. What I'm going to talk about is the United States Supreme Court, the politics involved behind it, and hopefully you'll walk away with the understanding of why it's so important who our president is, because that person has such a significant impact on our law via the judges. So our law is significantly shaped and reshaped by our judges. The United States Supreme Court is the final arbiter. So whatever that court decides in a case, that is the final decision. There's no appeal from there. That is the law of the land. Their decisions are final and so very important. There are a little bit about the court. There are 9 judges on the court. They're nominated by the president. They are typically selected because they are like-minded with the president. The judges are a way for a president to protect his or her legacy, because the president is restricted to 2 terms, 8 years. The judges now are appointed for life. So they can continue to advance the policies of the president, who's perhaps long gone from the White House, but their Supreme Court appointees live on. So many times presidents will seek to nominate younger judges so that their tenure on the court remains long. Trump had, of course, the opportunity to appoint 3 judges, Amy Coney Barrett, who is 52, Brett Kavanaugh, who's 59, and Neil Gorsuch, who is 57. Think about Justice Sotomayor, who is 70, and many have stayed on the court long beyond 70. So those 3 appointees have possibly long tenure. So it happens that judges create a lot of our law. And you might say to me, wait a minute, that's what legislators do. Legislators pass laws, judges then enforce the law. Yes, but they also interpret the law, and they do what is called fill in the gaps in the law, where those holes or ambiguities in the statutes that legislators pass exist. Legislators cannot anticipate every possible circumstance, fact pattern to which a law will apply. So it often happens that it's unclear whether the law applies in a given case. Someone has to make that decision. We don't go back to the legislator every time. It is judges that make those decisions. The Justice Benjamin Cardozo, who was a famous United States Supreme Court judge, and he was chief judge of the highest court in New York State. He wrote a book called The Nature of the Judicial Process, and he talked about these gaps. He said a judge legislates, adopts law. That's what legislators do. A judge legislates between the gaps. He, and I would add, or she, fills the open spaces in the law. Also, he stated, Cardozo, that this is the way courts have gone about their business for centuries. So, filling in those gaps, this is where the judges' views, their values, their political leanings can influence the law, because they bring those views with them to the bench. Sometimes the law is real clear and judges don't have to interpret anything. Let's say we're talking about a speeding case. The law is real clear. If we're talking about a highway, it's in the town of Brighton, it's 55 miles per hour. So there's nothing to interpret. If you're charged with speeding, the law is clear. 55 was the highest you should have been driving. But many cases are not so clear-cut. Let me give you a couple of examples, and then we'll see how this really impacts our law. I had a case, I had a client. The client was on parole. He had been released early from jail. He had certain rules about parole. One of them was not to be in a bar. Unfortunately, he was in a bar, and unfortunately, there was a fight in the bar. Police were called. Police know who in their geographical policing area is on parole. They knew my guy. They put two and two together and came up with believing that my guy was in the fight. I'm not sure that's the case, but nonetheless, my guy sees the police, knows that he's not supposed to be there, so he starts running out of the bar. Police see him, recognize him, and start running after him. My guy lives close to the bar. He is running down the street. The police are running after him. My guy's a faster sprinter. He gets up to his porch, and he gets on the porch, and he yells profanity, not smart, yells profanity to the police, runs in the house, and locks the door. Police eventually get up to the porch. They bang on the door. My guy doesn't answer. Police eventually go away, but charged him with disorderly conduct, which was, at the time, using profanity in a public place. So we now are...
We're done.
Is it? Oh. We'll never tell. You're safe here. You're among friends. So we're now going to argue that the porch is not a public place, that the porch is a private place. And if it's a private place, my guy is entitled to use whatever language he chooses. So it would have been great if we could have gone to the statute. There might have been a drop-down menu, and the legislature might have addressed all the places that were public places. But that didn't happen. So now somebody has to decide, is the porch a public or private place? We argued it's a private place, prosecutor argued it's a public place. And I submit to you, as with all of these issues, there are good arguments on both sides. Our argument is that the house is the most private place that we have in our life, and the porch is part of the house. Further, let's say you're going on a picnic. You might go to the park and bring your picnic lunch and your blanket and your basket of yummy food. You certainly wouldn't go up on somebody's porch and put out your blanket. So in that sense, it's a private place. The prosecutor rightly argued what goes on the porch is visible to the public. What you say and do on your porch, the public can see. Also, as there are certain people who will go on a porch, but you would never go inside. Maybe you're a candidate running for office. You just said the best thing is to go door to door. You go door to door, you're going to go up on the porch, you're going to advocate for your candidate, but if nobody answers the door, you're not going to go inside the house. So in that sense, the porch is more public than it's more public and not private. So those were the arguments. Somebody has to make the call. A judge makes the call. Here's one other example. I love this example. It involved New York City Uber when Uber was first coming. So the taxi drivers, of course, in New York City did not want to have Uber come into the city. That was a lot of competition and would take away a lot of customers. New York City had a statute that said only yellow cabs could respond to hailing a cab from the street. That was the statute. So now the Uber argued. Uber said, we want to come to New York City. When somebody summons an Uber from their phone, that's not hailing a cab from the street. Typically, hailing a cab from the street is putting your hand out and let the driver that way know that you want the ride. The drivers, the cab drivers all said that summoning with your phone is another way of hailing a cab from the street, and therefore Uber needs to stay out. Good arguments on both sides. Somebody has to decide it. That's the judge. How do they decide? Let's look at how they decide, because this is important. And then we'll look at some of the critical issues that judges have decided. So the first thing that they do is look for precedents, prior cases that have been decided. And our law says that judges should follow precedent because we like consistency in our law. How it's applied ought not to bear on which side of the bed a judge got up on. There should be consistency in the law. But there is no period after judges should follow precedent. It's a comma, and then it goes on to say, unless there's good cause to deviate. So the big case in our history, putting aside for the moment the abortion decision, would be Brown versus Board of Education. Separate but equal was the law of the land that originated in Plessy versus Ferguson in the late 1800s, and that was the law of the land until young Ms. Brown, or her parents, realized that schools for blacks and whites were not equal, that she was going to get a much better education if she went to a white school, and she challenged separate but equal. And the lower courts followed precedent and all said, separate but equal, that's the law of the land. Sorry, Ms. Brown. And some weren't sorry, but Ms. Brown was not going to be able to go to the white school. It then went to the United States Supreme Court. Now, the court could have followed precedent, and who knows where we would be today. But the court said, no, there's good reason here not to follow precedent, that separate was never equal, and separate but equal was reinforcing negative connotations about the black race, and that wasn't what this country was founded on. And the court said, we are reversing separate but equal. So the first thing a judge when deciding a case does is look to see if there's precedent. If so, should the precedent be followed? If there is no precedent, and this is where it really gets tricky, if there's no precedent, then the courts look at, give me one moment here, where did it go? Let's see. Here we are. So then we look at, the judges are going to look at legislative history. Sometimes there are hints from legislative history what the legislature intended. The judge is going to listen to the arguments advanced by the plaintiff and the defendant and consider those. There may be an amicus curiae brief. Some of you may have been involved in one of those. And that's a friend of the court, somebody who has an interest in the case but is not a party and wants to be heard on the issues that are presented. The court's going to consider those. And then here's where it really gets what I call squishy. Public policy, community values, what is the fairest? Cardozo said in his book, the judges look at logic, history, custom, utility, and the accepted standards of right conduct. So what is fair and what is right conduct is determined by those judges who have, for the United States Supreme Court, been appointed by a president who selected them because of the way they think and approach these issues, that it's consistent with the president's views. So very important who are our judges, and very important who is appointing our judges. So we, of course, want to elect and work for presidents who are going to appoint judges who think like we do. Then we look at other gaps in the law, and this is why it's so important who is our judges. There's a statute forbidding, I was realizing I did, statutes forbidding, I have a number of PowerPoints that didn't show them, but statutes that forbid burning the flag. well, sometimes protesters, as a means of protest, will set fire to a small flag and hold it up as a way of protest. Is that statute then unconstitutional, and does the right of free speech encompass the right to burn the flag? Is the right of privacy perceived in our Constitution broad enough to include the right to an abortion? The Constitution says nothing about abortion. It's judges who make those decisions to determine how broad is that right of privacy and does it encompass abortion. The Equal Protection Clause in the Constitution, is it broad enough to include the right to same-sex marriages? Constitution doesn't, of course, mention same-sex marriages, but it does mention equal protection. Is the Equal Protection Clause violated by affirmative action, which gives some preferences to some protected classes? That was another decision of the U.S. Supreme Court. The judges making the decision are bringing their views on these issues to the table. Those views get incorporated in our law, and then that's precedent for future cases. I'm sure this group doesn't need to be told of the importance of selecting a president whose views you share for many reasons. One of them is because they're picking so many of our judges. And know, too, that in New York and in many states, lower-level judges are elected. It's very easy for you to say, well, I don't know anything about these judges, I'm not going to vote for them. Those judges are critical. It's important to do your homework, find out who they are. There are some people who say party affiliation shouldn't be connected with our judges. I disagree totally. I think that party affiliation tells us a lot about where those judges stand, and their views are going to seep into our law when they're filling in the gaps. Another piece of politics in the United States Supreme Court is when do the judges leave? They often will leave when there is a president who will be appointing their successor who the judge agrees with. Some of you may remember Justice Douglas, William O. Douglas. He said, over my dead body, would he resign while there was a Republican president. And so he stayed after he became quite ill and had been encouraged to leave because he was quite compromised. But he was not going until there was a president. A Democratic president. We all love Ruth Bader Ginsburg. There was an argument to be said that she stayed too long, and she then freed up that position. And it just haunts me that Trump said he was saving Amy Coney Barrett to take Ruth Bader Ginsburg's position, like those two women are equal. It's like, oh my, it just haunts me. There are those who, and this is the politics of the Supreme Court, there are those who have said to Justice Sotomayor at age 70 that she should have resigned already so that it would have been Biden who would have selected her successor, since what happens next is unknown, and until recently there was reason to think that a Republican might be in the White House. One last thing, and that is Biden's proposal. You have heard about Biden's proposal for the court. This is not a pass the court proposal. He is not proposing to add new additional judges to the court. What he is proposing is very interesting, and it's a response to recent decisions and developments with the court. One, he is concerned about the court's decision that Trump, the president, is entitled to immunity for official acts done in the White House. One of the three components of Biden's proposal is that be reversed, that presidents are not above the law. If you commit a criminal act, whether you're acting in your official capacity or you're not official capacity, you're still liable. Connor mentioned the new indictment, which just came out in the last day or two, which focuses now, it sort of works its way around that United States Supreme Court decision and addresses issues in Trump's non-official capacity. But Biden said there should be no get-out-of-jail-free card for what you do in your official capacity. The second thing that, and I think this is a great proposal, he is proposing an 18-year term for United States Supreme Court judges. And he's proposing staggered terms so that every 2 years, one of the terms would be up, so that each president gets equal numbers of appointments, and we know that there will be a regular change in the makeup of the court. And the third thing is a binding ethics code of conduct for judges. We saw that Justice Thomas accepted lavish travel gifts from a Republican donor. More irksome was Alito flew to Alaska for a fishing trip on a private jet that belonged to a hedge fund manager, and here's the rub, who repeatedly brought cases before the High Court. That should never happen. And then, of course, we saw with also Alito the upside-down flag, which is a symbol of the protests about Stop the Steal from the 2020 election. So Biden has addressed all of those issues, and Vice President Harris has endorsed them all. So final upshot, there's one slide. Let me just, that maybe, oh well, you won't get to see it. It was, there's a picture of the, is it moving? Oh, great, okay. Oh well, this is it. Let me just, oh well, it's okay. I was going to show you a picture of the United States Supreme Court. It's sort of a cool picture. But the upshot is this. Judges have political leanings. Those political leanings ooze into our law. Federal judges are appointed by the president. Critically important, who is our president for many reasons, and one of those is their influence on our judges and the judges' influence on our law. Thank you for your attention. Thank you for your enthusiasm.